그럼 지금부터 첫 번째 발표 시작하겠습니다. 첫 번째 발표는 일본 지적재산고등재판소의 타카베 마키코 부장판사님께서 해주시겠습니다. 부장판사님을 단상 위로 모시겠습니다. 힘찬 박수 부탁드립니다.
It is my great pleasure to have this opportunity to make presentation in this conference. I will talk about 3 topics mentioned in the slide as overview. First, historical development regarding the legal system in Japan. Second, issues and solutions as to the double track system. And third, remaining issues. First topic is historical development regarding the legal system in Japan. The former Supreme Court's judgment about 100 years ago said that a judgment in litigation on patent infringement needs to be rendered on the premise that the patent is valid, even if it is obvious that the said patent is invalid. However, there are several problems as to this judgment. First point is that it is contrary to the principle of equity. The second point is that it leads to the increase of burden for the parties. The third point is that it leads to the delay of the proceedings. With the background of this criticism, Supreme Court's judgment 2000, usually called Kirby case, was rendered. The judgment said, when it is clear that the patent in issue has reasons to be invalidated, claim for injunction, damages, or other claims based on such patent right should be deemed as an abuse of patent right and prohibited unless there are extenuating circumstances. The effect of alternation of judicial precedent are: first, reasonable conclusion; second, solution of case with one time; and third, expediting of trials in patent infringement. Then came the amendment of Article 104(3) of the Patent Act in 2004. The revised law says, restriction on exercise of rights of patentee, paragraph 1, where in litigation concerning the infringement of a patent right, said patent is recognized as one that should be invalidated by a trial for patent invalidation, the rights of the patent owner may not be exercised against the adverse party. Where the court considers that the materials used for an allegation or defense under the preceding paragraph are submitted for the purpose of unreasonably delaying the proceedings, the court may, upon a motion or ex officio, render a ruling to the effect that the allegation or the defense is to be dismissed. Here, I would like to explain the current system regarding trial for patent invalidation and litigation of patent infringement. As to trial for patent invalidation, starting from JPO, then IP High Court, and finally Supreme Court. As to litigation of patent infringement, starting from Tokyo District Court or Osaka District Court, then IP High Court, and finally Supreme Court. This system called double track. Next slide, here I explain characteristics of the two systems. As to trial for patent invalidation, first is no limitation by the timing of the initiating of trial and the numbers of trials. Third is retrospective effect as to third parties. And fourth is request for collection in a trial for patent invalidation. As to litigation under Article 104(3) of the Patent Act, first is no ex officio examination. Second is dismissal of an allegation or a defense that unreasonably delays the proceedings. Third is relative effect of judgments limited to the parties. And fourth is patentee should trial for collection and defense of collection. Then the next topic, that is issues and solutions as to the double track system. I would like to start with issues arising from double track system. There are three major issues. First, it is unfair in that the defendant has double opportunities to defense, although the plaintiff has to win both in patent trial and in litigation. Second, it is contrary to the principle of solution at once and judicial economy. And third, there is possibility of the contradiction between trial decision and judgment in litigation on patent infringement. Due to this, legal stability and reliability of patent system will be deteriorated. Then, I would like to explain the legislative solution of contradiction of judgment. There has been a change in law in relation to a case where judgment for the patentee, that is the patent valid, was rendered prior to a decision against the applicant, that is the patent invalid. Former theory was that such a case constitutes grounds for retrial pursuant to the Code of Civil Procedure. Please note that this theory did not apply to cases where judgment against the patentee, which means the patent is rendered invalid, was rendered prior to a decision for the applicant, which means the patent is rendered valid. On the other hand, under the revised Patent Act, it does not constitute grounds for retrial. This rule also applies in the case where the decision of the trial for collection has become final and binding. Then, I would like to look to the effect of the law revision. Before the law revision, the alleged infringers still had an opportunity to prevail at trial for invalidation of patent, even if the infringer loses a litigation. On the other hand, under the amendment law, defendant must present assertion and evidence with respect to the grounds for invalidation timely. Then, I would like to move on to possible ways to avoid the contradiction between judgment and decision. Here, I would like to refer to the reasons for the contradiction. First is the difference in allegation and evidence. Second is the difference in the panel of the trial and of litigation. With this noted, possible ways for operational improvement would be, first, to have the same allegation and evidence to be submitted both in litigation and in a trial, and second, to have the same panel to handle both a case of suit against a trial decision on a patent and a case of an appeal against infringement of the said patent. However, there are limitations as well. First point is that on suit against appeal trial decisions, it is not permissive to assert a cause for invalidating a patent in relation to publicly known facts that were not presented for appeal trial examination and judgment. Second point is that the relevant panel in the court may not be able to handle both cases depending on the timing of a trial. Finally, I would like to move on to the last topic, remaining issues. The first issue is scope and precedent of suit against appeal trial decisions. In this regard, I would like to refer to two cases. The first one is Supreme Court's judgment 1976, which is called as knitting machine case. It is not permissible to assert a cause for invalidating a patent in relation to publicly known facts that were not put for appeal trial examination and judgment in an appeal to the determination for invalidation of a patent in a lawsuit for revocation of an appeal to the determination. The other one is Supreme Court's judgment 1980, which is called as package case. It is permissive to submit publications that were not put for appeal trial examination and judgment in an appeal to the determination to make clear common general technical knowledge. Next issue is limitation of chance of trial for collection. In this regard, I would refer to a provision of the Patent Act. Article 126, paragraph 2, a request for a trial for collection may not be filed from the time the relevant trial for patent invalidation has become pending before the Patent Office to the time the trial decision has become final and binding. This means that whether collection is right or not cannot be final and binding until judgment also becomes final and binding. Therefore, the patentee cannot collect the claim. Accordingly, courts must judge for re-defense of collection in many cases. The last issue is prohibition of double jeopardy. I refer to a provision of the Patent Act here as well. Article 167 of the Patent Act, effect of trial decision. When a final and binding trial decision in a trial for patent invalidation or a trial for invalidation of the registration of extension of the duration has been registered, no one may file a request for a trial on the basis of the same facts and evidence. After the law revision, the latter part of this article is party and participant. The flexible interpretation of the legal meaning in regard of the same facts and evidence is the first step to settle a dispute at once. With this, I would like to conclude my presentation. Thank you for your attention. 감사합니다.
타카베 마키코 부장판사님 좋은 발표 감사드립니다.